Hello and welcome to See You in Court, the podcast that informs you about the Georgia civil justice system, what it means to you, and how it protects individual rights. This podcast is a collaboration between the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Your hosts are robinfrazierclark and lestertate, who are both past presidents of the State Bar of Georgia and currently serve on the Board of Directors of the Georgia Civil Justice Foundation. And now this episode of See You in Court.
Good morning and hello to all podcast listeners and lovers of the law. This is the See You in Court podcast, and today we are happy to have a panel of expert lawyers and judges talking about the crisis that we're in now with the coronavirus crisis and the shutdown of our courts for most purposes. I want to introduce our guests first, and then we'll get right into the meat of it. First of all, we have with us Judge Carla Brown. She is a judge in the Gwinnett County State Court in Lawrenceville, Georgia. She was admitted to the bar in 1989 and appointed to the bench in 2003 by Governor Perdue, and since then has been reelected 4 times to that position. And I believe, Judge Brown, you're running for reelection again this year. Is that correct?
That is correct, if we ever have an election.
Okay. We'll be looking for the Gwinnett folks be looking for. Judge Brown, has worked with her colleagues to establish the Gwinnett County DUI Court and the Veterans Intervention Program, which is an accountability court. She was in private practice from 1989 to 2003, doing primarily felony criminal defense and representing fathers seeking custody in domestic cases. She has her undergraduate degree from Mercer and her law degree from Mercer. And I understand she was classmates at Mercer Law School with one of our other guests, Chris Clark. And Judge, we'll talk about the law school stories after we finish taping, okay?
I've already sent Chris his required bribe to remain silent.
Okay. We have with us Chris Clark, trial lawyer from Macon, Georgia. He is the owner and principal in his own law firm, Clark Smith Sizemore. He received his undergraduate degree summa cum laude from the Citadel, and then his law degree, as we said, from Mercer Law School. He was admitted to the bar in 1989 after serving in the United States Army. And he is a past president of Georgia Trial Lawyers Association, past president of Macon Bar Association, and member of ABOTA, American Board of Trial Advocates, and was on the State Bar of Georgia Board of Governors for a number of years. Welcome, Chris. And we also have with us Matt Moffett. Matt is a renowned civil defense attorney. He's a principal and owner in the firm Gray, Rust, St. Amand, Moffett, and Brisky. He is a past president of the Georgia Defense Lawyers Association, a member of the DRI Defense Research Institute, and has presented numerous times with that institute. He has tried over 100 trials and was admitted to the bar in 1990. And I can say from personal experience, Matt is a formidable opponent. So welcome to all of our guests, and thank you, and welcome to the show, and thank you for being here.
Yeah, let me join in Robin's chorus of welcoming the three of you. Thank you for coming in. I was sitting here thinking, if I needed to sue somebody, Chris is who I'd go to. If I got sued, I'd go to Matt to get my defense. And if I got to pick the judge, I'd pick Judge Brown because all three of them are just outstanding at what they do. And I'm gonna start today. We're in the middle of the COVID-19 pandemic, which is something unlike anything I've ever seen in my 30 years of practicing law. We had an earlier guest on our podcast was talking about that was admitted to practice law when I was 3 years old. He said he had never seen anything like this. So we're truly in sort of uncharted waters here. We are now under a judicial emergency order from the Georgia Supreme Court. Justice Melton put that in place to try to deal with the pandemic, and of course he's plowing new ground everywhere he goes because he hadn't seen this before either. But there are a lot of different aspects of that. And I think I'd like to just start with Judge Brown, because while Robin and I and Matt and Chris are in court from time to time, Judge Brown, you're in court, you're at the courthouse every day. So tell us how this judicial emergency declaration has affected the day-to-day activities of the courts, and maybe just give us a little hint of where you see it going in your view from the bench.
That's a really big question. It certainly has been interesting, to say the least. The challenges that we face are things that you take for granted every day. With all of us trying to operate remotely, thank goodness technology is what it is and allowing us to do that. But we're having to figure out very simple things, such as our e-file system in Gwinnett County is not yet equipped to do criminal e-file. So as a judge, I'm sitting here at my desk at my house, and I need to sign a bond order, for example. So I sign it, but then what do I do with it? So we figured out, a way to get an order filed with clerk when you're not physically present in the courthouse. So even the little things that we take for granted, we figured out. But I think with technology the way that it is, e-filing certainly is something that all the courts are fortunate to be starting. And if we can get criminal on board, then that'll be a big relief. We're moving forward. I think that we all have to adapt. We're doing hearings by Zoom a lot. We're trying to utilize open courtroom by live streaming to YouTube. I did a hearing on Wednesday with 15 attorneys in a wrongful death suit, and we held it completely by Zoom. I was on the computer. My court reporter was with me so that she could take the matter down. We're just all trying to figure it out, but that was done with a closed courtroom. And I think we're going to see a lot more things handled that way. I'm sure that Justice Melton, when he gives us more direction on Monday, will hopefully give us some more things that we are able to do by video. And I think in the future, the big challenge that we're going to have as far as the courts are concerned, or the courthouse is concerned, are the calendars, those big calendars that we're all used to having, the arraignment calendars with 120 cases on them, and everybody brings their mother and their brother with them. Jury trials. How does a jury trial look in a courtroom that can only have 11 people in it if you go by 6-foot social distancing? How do you have a jury of 12 when your courtroom isn't big enough? Right. So lots of things to figure out, and some interesting options being put out there.
So, Matt, I'll sort of go to you next. Robin and I think both began our careers really doing defense work. And I did some defense work probably till about 10, 15 years ago. And defense work, I think Chris would probably agree with me about this. To some extent, it's more reactive than proactive, because when somebody's filing the lawsuit, they're trying to get some kind of relief. And if you're defending, you're trying to fend off or show why they're not entitled to that. And of course, a lot of the work that you do is with insurers or other people who are corporations that have sort of professional claims handling, practices. So how has this affected them, and how is it affected their view of claims that, we're not really having jury trials? And, I know a lot of folks talk about how cases settle on the courthouse steps. That's usually when both sides know what their risk is, the point at which they know it's about to leave their hands. So how are you and your clients dealing with the situation?
Well, good question. Let me say this. Insurance companies want to close files. And as soon as they can close a file, they like that. Mm-hmm. The efficient resolution of a case. So now is an opportunity to engage in the reasonable resolution of these cases. That may not be to the economic benefit of the defense lawyer at the given time, but if we defense lawyers can fairly and reasonably and efficiently resolve these cases, then there'll be another case that we'll handle thereafter. So what I've seen now is a push by certain insurers. I even had an insurer within the last 2 weeks send me an email and ask me to identify every single case and inform them as to how I was going to reach out to the other side to attempt to resolve it. And
interesting.
The reason they asked me about that was because they thought that once this order lifts and once we start to move back to a sense of normalcy, they're going to be flooded with new cases, so they want to close.
Right. And I suppose too, from I want to be very clear. I'm not being critical of this, but insurance companies, part of their job is to try to grow the money that that they have, so that they have enough money to pay claims, at some later. And the stock market's been up and down, the net results being sort of flat. So they're not really able to make a lot of money, off that right now anyway, it seems to me.
Well, you would think that the longer they can hold the money, the better they would like it. But I can't say that I've necessarily experienced that. I think everybody has metrics. And the people that work at these insurance companies, they've got somebody looking at them and they're using metrics. And one of the metrics is, how long are your files open?
Right.
How much are you spending to defend the case? And let's move the case to resolution. So that would benefit plaintiff's bar, I would think.
Yeah. And the liability, for a company, their stock price might be affected by having a greater number of liabilities, as well. Yep. So Chris, you represent a lot of individuals who are, who have claims and who were maybe not making it very well in the pre-COVID-19 world financially, because they were hurt on the job, or because they were in a car wreck, or because of medical malpractice, or whatever else. How has this affected them?
Well, Lester, interestingly enough, I don't think I've had one call from a client saying I'm in a hurry or I need to get something done. As you know, on our side of the case, you try to set people's expectations early on, make them explain that certain things have to be done to get the value of the case. And so, at least in our practice, we've been very fortunate that people do not seem to be in an urgent mood or a need to get the case resolved. And I'll echo what Matt said. I mean, our experience, and of course it's only six weeks or so, but resolving, and the cases that aren't resolving are cases that just there's a difference in opinion about the value of the case, and that's going to be for a later day of trial. But the cases that are resolving, people put their heads together and they say, yeah, that's the fair value of the case, that's the settlement value of the case, and we can resolve.
Yeah, I've settled 2 cases, through doing Zoom mediations and whatnot. So.
I was going to say, let's talk a little bit about virtual court, Judge Brown, virtual hearings, virtual mediation. I know Chris has done a couple of virtual mediations. Matt probably has too. I've done depositions, hearings. Judge Brown, how's that working for you? And do you feel like you're missing anything in hearings by Zoom or virtual hearings?
Scheduling, I think, is the biggest issue from my standpoint. As far as the interaction with the attorneys, I think it's great because you're right there, 2 feet from you feel like 2 feet from them, and I can see them, I can hear them. I think it's fantastic just from the standpoint of the ability to see and hear. As far as missing anything, I don't think so. I think the scheduling is really the biggest issue that I personally am facing. Attorneys, we're all famous for saying something's going to take 5 minutes when it's going to take 15. And if you're in a hearing virtually, it's hard to tell the other people that thought they were going to start a hearing at 3, hey, go get a cup of coffee and check back in at 3:30 because this case that I'm in right now is running over. I mean, you can do it. We certainly have the ability to communicate with people that aren't in that particular hearing, but it's just it's a challenge to schedule. It's a challenge to take one case that might be a short case ahead of a case that maybe on the calendar is behind it, but it's going to be much shorter. But I think I'm definitely getting more comfortable doing it. That's for sure.
Chris, how about the virtual mediations that I know you've conducted in the last few weeks? Can you tell us about those? How they worked, and if you thought it was a detriment or benefit or the same?
It's kind of a case-by-case basis, Robin, but my experience so far, and actually we've done 4 virtual mediations in the last 6 weeks. And we've had, I think, 2 resolved and 2 did not resolve. And if I was being honest about it, if we were in person, I think the same results would have happened. I don't think it would have made any difference whether we were in person or by Zoom or virtual mediation as to whether those cases resolved. Again, it's just cases that the lawyers and then the adjusters and people, we just have a big difference of opinion about what, at least at this stage, what the case is worth or what it's not worth. The cases that did resolve, it was really as if we were together. And I frankly, from my standpoint, being in the middle of the state, I was so glad I didn't have to drive to Atlanta and mediate a case. It's nice from that standpoint, logistically, particularly the lawyers even further south from me who have to come to Atlanta. I mean, I'm sure they're loving virtual whatever, so that they don't have to get in the Atlanta traffic.
Matt, how about you?
Well, the one thing, just to add to what Chris said, if Chris is on the other side, Lester, or you are on the other side of me, I want my claims person, the decision maker, to hear from you and to hear from your client. Because I want them, they've probably never seen your client, they've never evaluated your client. I would think that would help you maximize what you can do with the case. It's challenging when we have Zoom. It's not as effective. But I've had 3 Zoom mediations within the last 3 weeks, and they've all settled. So,
yeah, I was going to ask you, Matt, because when I was in the defense business, I had one client who represented the power company, and the claims guy would go to me. You go with me to a lot of depositions and mediations. I didn't have to write those letters back, but with particularly people who handle a large volume of claims. And this is something that I think the public doesn't realize sometimes, but for a plaintiff in a case, that's their case, and that's usually their only case. They might have a workers' comp and a car wreck case or whatever, but that's usually their only case. So they're in to go in there and be in there and hearing that. And so sometimes with the claims people, it's not that they're uncaring or don't want to see exactly what the other person looks like, but they've got 100 files, sitting over there to do that. And so I've run into situations where, the decision maker, the claims decision maker doesn't show up, they just kind of phone it in. And that's kind of frustrating, sometimes to the folks on the other side. So my question is, I'm wondering if, having had this virtual mediation thrust upon us a little bit, is it something that you see that claims people maybe like more, and it's really easier to get them to participate in because they can do it without having the travel time back and forth and that kind of thing?
I think it is. I don't think it's as effective as having them present there. Certainly the type of case would or would not necessarily arguably justify them being actually present because they've got a volume like you mentioned. So yes, I think Zoom would be a great benefit so they can at least see the plaintiff, see the lawyer, see any presentation, which I always invite, because my role is just to continue to funnel information with evaluation, but funnel information that's new to the decision maker. I would think that's what the plaintiff's bar would want me to do. I think that's part of my job, is to get that information over there. It also helps me cover my rear end in case I end up on the wrong side of a verdict and somebody wants to say, you didn't tell us this. Well, I'm telling you everything. So that's my role.
I always thought that's one of the most difficult things for civil defense lawyers to convince other people of is it's not their money. They're not the one that's paying, and the whole thing. So, Judge, let me go to you for just a second and ask you: Can you ever see, just logistically, put the Constitution and other things aside for a moment, but could you see handling a virtual Zoom trial via some device like Zoom? Do you think that's something that could actually really be done at some point?
Are you referring to a jury trial?
Yes, an actual jury trial. Because now what we're doing, because we have a lot of listeners who, aren't lawyers, and the distinction between a hearing and a trial is sometimes lost. We have a lot of hearings where we go in front of a judge and we argue what the law ought to be, or we argue about what ought to be admissible or something like that. But ultimately, you're typically headed for a jury trial where you have 6 or 12 citizens come in, actually hear witness testimony, then go and deliberate and reach a verdict about that. And so that's a lot to pack into a Zoom meeting. And it's a lot different from what, the appellate courts seem to have just sort of seamlessly gone into hearing arguments from lawyers because there's less moving pieces. And so I just wonder if logistically that's anything that you think you could ever manage.
Could it be managed? Yes. Do I think it's realistic to have jury trials virtually? At this point, I don't see it. With my knowledge of what technology we have available right now, I don't think, first of all, that you could have the safety controls in place that you need when you have a jury impaneled. There's too many options for outside influences. Anything short of a jury trial, certainly. But I also believe, as a practicing attorney, when you're in that courtroom, I know, Lester, when you're in front of that jury panel, you're trying to get to know them. You're figuring out whose mama and where they eat dinner, and have you run into them on the golf course. You try to really read the people on that panel. And as an attorney, it would be really awkward, to try to get a true feel for someone virtually. So I think it would be exceptionally hard to pick a jury. And I think it would be exceptionally hard to manage it virtually.
One of the things that we've talked about is if you were to do a virtual jury trial, how would you make sure every potential juror has high-speed internet, has a device, a tablet or a laptop to be able to use? Who would be responsible for supplying them? Where would they use them? Would you ask the attorneys to go in together and supply them to jurors? A lot of questions that I don't see personally as a trial lawyer. I don't see happening. I don't think I would ever consent to a virtual jury. But let me ask the panel this: do you think it's a matter of consent, or could a judge order you to do it? And if the judge did, what would you do then? Because I know what I would do, but I'm curious what my other friends would do.
Matt, you want me to go? I don't think anybody really knows the answer to the authority of a court to order a virtual trial. I think that is a constitutional issue that would have to be decided. I think I probably lean like you do, Robin. I would not. If I had a client who didn't want to do that, and I probably would advise them that it's untested waters. I would appeal that. I would not to a virtual trial. The thing that I share, Judge Brown, my biggest concern, technology issues aside, is the security associated with a trial. I mean, it's very easy to see in this environment how a juror could have 2 or 3 family members in the same room. Yeah. Maybe the juror is just by personality a shy person or not a very assertive person, and somebody not a juror influencing that trial. I know that would be a huge concern because they're in rural venues. We try a lot of cases in rural venues. There are lots of issues at play in those rural trials that perhaps are not everybody's not thinking about it.
Mm-hmm. Matt, I know you like to establish rapport with the jury just as much as a plaintiff's attorney does. What do you think?
I agree with Chris. I would not be inclined to prefer any type of virtual trial over the presence in a courtroom of everybody who's important. I think accountability doesn't exist to the extent we would prefer it to exist when we're using devices. I just feel that way. I'm not in favor of it.
Yeah.
I don't know how we're going to solve this problem. Maybe we go to 6 jurors.
Yeah.
No, defense lawyers aren't supposed to say that.
Yeah.
I know there was a defense lawyer in Macon, Chris, who told me the other day that he actually made that offer. I don't know if it was to you or to somebody else. Well, I'll agree to 6 if you'll agree to cap your verdict at the insurance limits. And the answer to that was no, but I thought that was an interesting proposal.
I do too.
That's not a bad compromise. I could see that being done in the right case. And 6-person juries, state court, you have those. I've tried many cases for 6 people, but that is something that the judges here in Macon are discussing, and they would like to do it. It's going to take consent from the defense side, and I suspect the plaintiffs will have to offer some carrot, like you're describing, Matt, to encourage those trials to happen.
Well, I think in metropolitan Atlanta courtrooms that tend to be pretty small, I think even a 6-person jury might be difficult. But in some of the rural courtrooms that I know where you try cases a lot, Chris, I mean, I know you try all over the state, but I've tried one, for example, in Peach County that had the most magnificent courtroom you'd ever want to lay, like something out of a movie, you could probably do 6-person jurors because it's huge. But I don't know about our small courtrooms here.
Yeah, I've heard people complain that we used to have great towering lawyers that tried cases in little wooden courthouses, and now we've got little wooden lawyers who try cases in great multi-storied, courthouses. But some of those old courtrooms really do have a lot of room, to sort of spread out in it. And they probably lost. They were built that way so the whole town could come watch. And now they've sort of lost their allure because people would, stay home and, watch Goliath on Amazon Prime or whatever.
But I share your thoughts, Robin. The rural courthouses still, for the most part, are big courtrooms, and you could easily do 6-person trials. Interesting enough, in Chris County, they many years ago tore down their big courthouse, their old big courthouse, built something that looked like an elementary school. And then they finally realized that was not a good thing, tore the elementary school courthouse down and have built a new courthouse that goes back to, years and years ago. And they got great courtrooms, 2 big, great courtrooms to try cases in.
So have any of you taken a deposition by Zoom or by video?
I've taken one, Lester, and it's what I would call a non-confrontational deposition.
Mm-hmm.
I just simply want to know what the person knew. But and Matt may disagree with me about this, but I had a hard time accepting that I can get the same information from a witness through a virtual deposition that I can in person. I mean, frankly, part of a lawyer you have is an adversarial system, and you have witnesses who may not really want to tell you everything, and they may not want to have to agree with a certain document that you're putting in front of them, and it's your job as an advocate to try to get them to agree. And I think that has to be done in person myself.
Yeah, I talked to a defense lawyer the other day that I was working on settling a case with, and he had taken one and said that if he, like for a car wreck case, wherever you go in was light green, that kind of thing, it worked pretty well. But he didn't think it would work very well for things like a medical malpractice case or a commercial case where you had a lot of documents and, and things sort of like that. So Judge Brown, go ahead, Matt.
Just very quickly. I had an insurance client that instructed me not to take a Zoom deposition of a plaintiff. I thought it was a simple case. It wasn't a major case. I didn't think it'd be that big of a deal, but they refused. They did not want me to do it. They wanted me to wait. and another case where I said we should go ahead and take a discovery deposition of the treating doctor. I just want to ask him within 30 minutes what his opinions are, because I can't really tell from the records. Is it related or not? Why not? What's the evidence? No big deal. But I agree with Chris. I wouldn't touch, an important, so to speak, deposition of a plaintiff necessarily in a, big injury case or an expert in a med mal case. I agree with that. Absolutely.
Interesting point of view. I've done 3 depositions while we're on the shutdown, and 2 of them were the defense attorneys taking my experts in a med mal case.
Wow.
And you would know the guys, you would know the defense attorneys, and it was really short compared to a typical expert witness test deposition. Very short. I guess they got I guess they get okay. But, it's interesting. They didn't have any problem, but I don't understand even the need to do the expert depositions. We're not going to be trying. I don't think we're going to be trying that case anytime soon. So I don't know what the rush was, but they felt like they needed to go ahead. So I said, okay.
So, Judge Brown, are we going to be backlogged if we get to the point that the courts get back to normal here? Are we going to have cases backlogged because we can't do jury trials right now?
I think a lot of that's going to be up to all of you attorneys out there. Hopefully there will be more settlements possibly than normal. I'm hoping that the reverse isn't true. I hope that there's not a drag your feet opinion from one side or the other. But, definitely we're going to have somewhat of a backlog. One thing that we're trying to do, we are doing in Gwinnett as a joint state court bench, is we're sending out a calendar. This is our plan anyway. Send out a calendar in June that looks like a jury trial calendar, but it's not. So it would go out with all the cases on it that, for example, might be called in for a jury. And what we're seeking are announcements. We're trying to get information from the attorneys about, would you consent possibly to a bench? Would you consent to a 6-person jury? So that we know when jury trials do get up and running, we'll have a better feel for our calendar. And those 6-person juries, those are going to be the first cases that get tried. So if somebody really wants a trial, let the court know, hey, we'll go with 6, because that's going to be a lot more manageable than when we get back to 12. I'm just not sure when that will happen, but there's definitely going to be a backlog, in particular for the really big civil cases, the really big complex cases that take a week or 2 to try. We only have so much time that we can designate for those trials anyway. A lot of what we're using are senior judges to come in and help us with those lengthy trials. And so just the scheduling of those is difficult. And there's only so much space and so many courtrooms to be used. So a little bit of a backlog, but we're going to try to do everything else that we can to get cases in and resolved short of those lengthy jury trials.
I'm curious what the panel thinks it will take before we can get back to 12-person jury trials like before this crisis. Is it going to take a vaccine? Is it going to take a reliable treatment? Or are you going to have to screen everyone who comes into the courthouse by temperature, or have some sort of proof that they're not COVID positive? What do you guys think about that? Matt?
Well, herd immunity or a vaccine, or the developing science to support the safety precautions that we need. I don't really know what else to say about that. I don't see jury trials this year. Especially if we have a rebound in the fall.
Mm-hmm. I don't think I see jury trials either until we have, I think, a vaccine, because I don't know how you are able to compel a member of the public to come in to serve on a jury when you may be putting their life at risk. I don't know how the state does that.
And how do you assemble in a jury assembly room, say DeKalb County? We've all seen that room, or Gwinnett County, obviously. You pack everybody in and they have to stand around and go to the front and sign in and sit down next to somebody. And
yeah, I don't know. I wouldn't want to do it. I wouldn't be willing to serve right now.
Yeah, this is Chris. Even if a court decided to send out subpoenas, people are just simply not going to come. And so what's the court going to do? Are you going to arrest them and put them in the sheriff's or bail? The last thing a sheriff wants is more people in his jail, or her jail.
Last thing an elected judge wants to do is arrest a person for not showing up for jury duty during a virus crisis either.
That order will not have my signature.
I wouldn't think so.
I'm going to throw another aspect of the COVID-19 thing out there because it's been batted around sort of politically, and I'll tell you what my thought is, and I kind of want to see poll around the horn here and see who agrees with me and who doesn't agree with me. But there was some stuff in the governor's initial order. Or maybe it was the subsequent order about providing some sort of immunity for people who were medical professionals who are working with, COVID-19. There's been some talk in the U.S. Senate, for example, that if there's another round of stimulus, that this really needs to be tied to some sort of immunity for employers where people are going back to work, that they can't sue their employers over coronavirus and whatnot. And I guess my view of all that is, I just don't think you'd have a very good medical malpractice case against a hospital that was overrun with coronavirus patients, or it wouldn't be something I'd want to waste my time with. And my feeling about all that is sort of the jurors know all that, just like the jurors are afraid to come down to the courthouse, while they're, while this is an issue, this pandemic is an issue. And so I've thought it's sort of self-fixing, out there. And I don't think insurance companies would evaluate a claim as being worth a whole lot, in settlement, if you were suing a hospital or whatever. On the other hand, if you've got some, nursing home, we've heard some real horror stories, about things like that. Jurors they can see the plaintiff's side, on that as well. So I'm curious to think, and I'll just start with the plaintiff, with Chris up there. Do you agree that that's something that sort of has its own fix baked into it?
Yeah, I do, Lester. Obviously, I'm fundamentally opposed to government just deciding that this is going to get immunity or this is going to get a different legal standard because of a particular event. I think the best people I've ever seen in our society to figure that out is a jury, whether it's 6 or 8 or 12. And so why tinker with the rules? Let the jury figure that out. And just like you say, are they going to hold a doctor liable for trying to his best for a COVID-19 patient? Heck no. Are you wasting your money and time on that case? Absolutely. But let them evaluate, did the nursing home properly treat its patients? Weeks and weeks after COVID was known about, did they properly take the steps? Let the jury decide that. Don't, before the jury ever gets a chance to decide it, just give somebody blanket immunity.
I think everybody has to be reasonable and follow the law. In the context of an employer, I would think that workers' compensation may take.
Yeah, exactly. Exactly. Yeah, I think a lot of it is, I think it scares, it sounds better as a political thing. And I suspect that all of us we certainly have a greater knowledge than average about the system and how it works. But we have a greater trust in it, probably too. Judges don't get to put their own opinion in very often, but we'll give you the opportunity to do that now.
All I can say is I see a whole lot of motions for summary judgment coming down the road that are going to look a whole lot different than they have in the past.
Well, I live in Druid Hills, literally around the corner from Emory University Hospital and the CDC. And when I go on my walks down Oakdale Road or Springdale, it's house after house has a sign about the Emory healthcare workers being heroes, and thank God for our heroes, and thank you so much, CDC. And there's no way I'm trying a med mal case anytime soon in this area, that's for sure. I mean, all the healthcare workers are now lauded as heroes. I've got some pending med mal cases. I'm going to try to let all this die down before I even push them. I just think we just need to get over this before I take those to court.
So, have any of you, and I think most of us on this, are probably, we probably all argued appeals and been in the appeals courts, but most of us are probably more active in the trial courts, than we are in the appellate courts. Have you all followed the, what the Supreme Court, Georgia Supreme Court's had some oral arguments. They're also doing telephonically, the U.S. Supreme Court's doing some telephonic arguments. Have any of you followed that or have an opinion about how that's gone?
This is Chris. I watched the oral argument in the Georgia Supreme Court, which is a med mal case. And of course, they did that, in the same sort of fashion virtually. And it seems to work fine. I think consistent with what Judge Brown is saying, oral argument in front of a judge or a panel of judges this is a perfectly fine venue to do that. It'll work fine. And arguably, maybe the lawyers might even be a little better prepared. It's easier for them to look at their notes and easier for them to look at and get organized in a table in front of them, perhaps. And maybe some lawyers are a little more comfortable sitting down than they are standing up. But I think there's just a big difference in oral argument in front of a judge or a panel of judges in a trial. That's a huge difference. I just don't think virtual trials, we just don't have the technology yet. Maybe one day we'll have it, but I just don't see it today.
Yeah. I do focus groups. I know you do too, Chris, and I know Matt does, but I don't even like to do virtual focus groups, even though they're kind of becoming the go-to now. I want the feedback right there, the rapport with those focus group jurors. I don't think I would trust the results even from a virtual focus group. What do you say, Matt?
I agree with that. I don't think you get honest feedback to the extent you do when somebody is sitting there before you or engaged in a group dynamic, so to speak, with 6 other people in a room debating the issues or talking about the facts and evidence and how the law might apply. That's the way I see it. Now, I do believe these Zoom hearings, just to talk a little bit about what Chris had to say, and I agree with him.
Yeah.
I hope these Zoom hearings will even be a benefit to the court so they can become even more efficient. It takes a lot of time to assemble all these people and go through all this process. And I had a Zoom hearing today, a motion hearing on a Daubert case. We had the expert right there. We had the judge, all the lawyers, and the expert got to testify. I got to cross-examine him. I thought it worked fine. I didn't have any issue with it. And, I had all my notes, Chris, right there. I had 2 computer screens going, and I thought it was easier. And that hearing started at noon. It was over by 1, and it took me 5 minutes to get there.
I was going to say it definitely saved you driving time and a parking fee and that sort of thing.
Well, that's one of the big things. I'm about 40 minutes if there's no traffic outside Atlanta, and about 2 hours if there is any traffic outside Atlanta. And when you're going to a hearing, you're worried about, am I going to make it on time? Because you got all those people there waiting on you. Don't want the judge mad at you, for showing up late, or your client wondering where you are. So there are some, some good aspects, I think, to some of that. And so I'm going to ask Judge Brown to sort of finish up here. But, one of the things that out in the rural areas, particularly that we hate, that we use all the time, but I've come to hate, is the so-called calendar call, where everybody that's got a case in front of the court all shows up in one of those big courtrooms. And, and the biggest lie, other than your checks in the mail, is ready when reached, that we're going to be ready. You ready to try this case? And now a lot of courts, and in particular, as we have younger judges and judges that are more technologically savvy, now people are making announcements by email or or we actually have this thing called the telephone that's been around for a long time. You could call the judge's office and make your announcement. So do you see the calendar call finally getting the kiss of death and COVID-19? And is there any other change that you think is probably going to be permanent, is going to change us, is going to stick with us?
We buried our calendar call, so to speak, probably a year ago. It's always great to see everybody, but we stopped doing in-person calendar calls a long time ago. A lot of the judges in the circuit have, begun doing just phone-in calendar calls or email calendar calls, and I think that will be the way of the future for everyone. The one thing that I think we're going to see, that we'll have to have some more technology trials and tests, but arraignments are another thing, not just calendar calls for trials, but arraignments are another thing where we usually have 120 cases, coming in at one time. When we do arraignments, we usually don't even split them up between morning and afternoon. We throw 120 on a 9 o'clock calendar, and we're usually done by noon or 1. That's not going to happen anymore. Dealing with pro se people, unrepresented people that think that they need to come to court, they need to see the judge, and they're not sure what to do otherwise. I think that's going to be the population that we have to get comfortable with technology. We're looking at doing an online waiver of arraignment potentially in Gwinnett, where someone would log onto Gwinnett courts. They would view a video that would go through the normal arraignment dialogue, where they're advised of, what today is all about, and you're going to be given a copy of your charges, and these are the type of pleas you can enter. They would electronically sign some sort of document saying that, they were advised of all this, and then they would receive by email a copy of their accusation. And so I think that's the way that we're all going to have to start thinking.
I may be the only one that, other than you, Judge, on here that I have done and still do a fair amount of criminal defense, work. And I tell clients all the time, the arraignment is a throwback when the population was illiterate and could not read, and you didn't have photocopiers. You had scribes, and they'd call people in front of the court and read the charges to them so that they understood it and could be prepared to come back. And, nobody that has a lawyer is being arraigned anymore. It's just a docket control device right now.
Yeah, absolutely. And so that's going to change as well. Arraignments and calendar calls both are going to look very different.
That's great. Well, Robin, do you have any more questions for these folks? Or?
No, I just want to thank the panel again for agreeing to be with us. And I wanted to go through and let the listeners know where they can find out more about each of our panelists on their websites. Judge Carla Brown, Judge Brown, you have your own website. I was going to give the Gwinnett State, but you have your own, and I didn't write it down, but is it judgecarlabrown.com or?
It is.
Judge Carla Brown, yeah, I think that's what it is too. I saw it today, but judgecarlabrown.com, and you can learn more about Matt Moffett and his law firm at GRSMB.com. He gets the award for the most names in a law firm. And Chris Clark, you can find out more about him and his firm at clarksmithsizemore.com. And in closing, I want to say a couple of things. First, our podcast title is See You in Court, and Lester and I find it very ironic that our episode today is about not seeing you in court, seeing you in virtual court. The irony is not lost on us about the name of our podcast. It's sponsored by the Georgia Civil Justice Foundation, and one thing we want to ask each of our guests that appears on our podcast is their definition, their personal definition or notion of what justice is or what justice means to them. We'll start with Judge Brown. Judge Brown, would you share with us your definition of justice?
I tend to go simplistic on something like this, and my definition of justice is really just fairness and accessibility. From the standpoint of being a judge, the most important thing that I can do is to simply be fair. I think following the law comes without saying, but consider that the people in a courtroom, while it may not be of worldwide importance to me or the lawyer, to that person that is there in court, it is the most important thing going on in their lives at the time. And to listen and to be fair, I think is the biggest thing that I can do in order to respect everyone's right to justice.
Well, and I would say it is the opportunity for any individual, any entity, anybody in our democracy to have their issue, their dispute, whatever their problem is, resolved in an unbiased, impartial, rules-based forum that then has some oversight responsibility or beyond that. And if we will lose our democracy if we do not continue to provide people the opportunity to have an unbiased, impartial, rules-based forum, whether that be a trial court or sometimes another forum in administrative procedures, so that people can get their issue resolved. When you disenfranchise people from that sort of system, you will have lost the democracy.
Thanks, Chris. Matt?
All right. Well said, opposing counsel.
I agree.
Well said, Judge. This is what I think. I think justice is the fair and reasonable resolution of a dispute. And we lawyers on all sides and judge in the middle have a professional responsibility and obligation to advance that.
Well said. Thank you, Matt.
Thank you.
Thank you all guests. We appreciate you, and thank you for being with us.
Thank you
very
all
much.
both. We really enjoyed this. Thank you. With COVID-19 all across not just the country, but the world, we've talked today about how it affects our courts. But the one group that is probably the largest in the United States is the American Bar Association. And I've been fortunate enough to represent Georgia in the American Bar Association's House of Delegates for about 8 years now. And this week it was announced that the American Bar Association's meeting in Chicago in July, end of July, 1st of August, is going to be held virtually. And that meeting is really a conglomeration of meetings because the ABA has groups that just do personal injury stuff. They have groups that do corporate things, groups that do bankruptcy, judges, all this. So it's like about 5 conventions rolled into one. And so they are planning to have nearly 500 meetings at this event that includes convening the Board of Governors to discuss association matters, and the House of Delegates, which has 500 members in it, to take up a number of policy proposals. So my kudos are off to the ABA, because I think if they can figure out how to get all those groups together and conduct a meeting like that, then we might actually have some hope of having a virtual jury trial at some point.
Nicely done. Well said. My event in the news this week that struck me is actually a criminal case, but because we're talking about jury trials, and because we have unanimous jury trials in Georgia, meaning that a jury's verdict must be all 12 or you don't have a jury verdict, is a case that came down from the United States Supreme Court this week, Ramos versus Louisiana. And the Supreme Court of the United States held that the Constitution requires all criminal trials to be by unanimous jury vote. In 2 states, it used to be in a bunch of states, but in finally, still in 2020, there were 2 states left that would take away a person's liberty, put them in prison for the rest of their life based on a non-unanimous jury vote, 10-2 or 9-3. That was Louisiana and Now I forget, but I think it was Oregon.
Oregon.
And those are the only two holdouts, so that technically this case applies to those two states, but it made it clear that is unconstitutional. Mr. Ramos will certainly get a new trial. He may just simply be released since he has served a bit of time already. I bring that up because, and I'm not going to get into the greater political aspect of that opinion. There are some political issues involving that opinion that have others worried and concerned. But I do believe, and this was on, I don't remember the vote on the Supreme Court, but it was authored by Gorsuch. Can't pronounce his name very well. And I think it was right. I think it came out right that if you're going to put somebody in prison, if you're taking a citizen's liberty away, it should at least be by unanimous jury vote, as we have here in Georgia. So it's a long opinion, 90 pages, but that struck me as a positive note from the United States Supreme Court this week.
Absolutely.
And with that, folks, thank you again for listening. Thank you to the Georgia Civil Justice Foundation, our sponsor, and thank you to our producer extraordinaire, Raz Misher. And until we see you again, we'll see you in court.
Thank you for listening to See You in Court, brought to you by the Georgia Civil Justice Foundation and the Georgia Institute of Technology. Please subscribe to this podcast and consider writing a review. You may find related documents to this week's episode on our website, seeyouincourt.podbean.com. Please send any questions, suggestions, or ideas to seeyouincourtpodcast@gmail.com. The producer of this podcast is Raz Misher. We thank Noreen Hassan, Associate Professor and Director of Outreach and Community Engagement of the Georgia Institute of Technology School of Literature, Media, and Communication, and the Georgia Tech students who help bring you this podcast. I'm Fred Smith, Executive Director of the Georgia Civil Justice Foundation. You may learn more about the foundation at fairplay.org. On behalf of Robin Frazier Clark and Lester Tate, until our next episode, we'll see you in court.